Hello, my name is Rachel Falcone, and I am writing about the substantial similarity standard. The title of my paper is called Creating Consistency with a Misunderstood Standard, the Substantial Similarity Standard in Evidentiary Law Defined. This is my screencast PowerPoint presentation discussing the research question and the research that I've done for this paper. I hope you enjoy! Continuing on with the gaps within the case law, Cooper Tire and Rubber Company versus Crosby. This is the case where the trial court correctly applied the standard and found the evidence in the case did not prove to be substantially similar. The case was then taken to the appellate court, where the appellate court incorrectly applied the substantial similarity standard. The appellate court believed that the trial court erred in not admitting the evidence, and so the appellate court believed that the evidence was substantially similar, and the case went to the Supreme Court of Georgia, where the Supreme Court found that the appellate court had erred, so it reversed the case back to the appellate court because of the error. United States versus Johnson. The United States versus Johnson. Johnson is a case where the substantial similarity was applied incorrectly. In this case, the appellate court still affirmed the lower court's ruling, even though the trial court admitted evidence in violation of the federal rules of evidence. The appellate court ultimately affirmed the conviction because they deemed the error to be made by the trial court to be harmless. However, that is proof of an inaccurately applied substantial similarity standard where evidence was admitted, but it also violated the federal rules of evidence. The findings and perspective of this paper. Inconsistency across courts is a result of lack of proper knowledge, vague and subjective, leading to prejudicial impact, and when substantial similarity has probative value. These are three of the main things that cause inconsistency across courts. The lack of knowledge is some courts' misunderstanding and misapplication of the doctrine may result from the lack of information and analysis of the substantial similarity doctrine in academic literature. In most cases, the outcome is consistent with a correct understanding of the substantial similarity doctrine, but the court's application of the doctrine seems to indicate that the proper outcome was obtained by luck or intuition, rather than proper legal principles. Vague and subjective, leading to prejudicial impact. There's no proper definition for the standard, and the problem with that is it leaves room open for interpretation. In each jurisdiction, the doctrine will either 1. Remain a narrow and specific doctrine designed to facilitate courts' screening of other incident evidence, or expand to exclude all other evidence regardless of the purpose for which it is offered, and then has little probative value. The standard is designed to ensure that the prior act or statement is probative of the issue in the instant case, rather than being used simply to show that the person has a propensity to engage in certain conduct. If the evidence has little probative value, but the court still admits the evidence because they find some kind of similarity, then it creates inconsistency case to case. In conclusion, the substantially similar standard has been taken outside its original scope and must have probative value and must be applied within its original scope in order to be consistent across courts. My restated thesis for this assignment is the substantial similarity standard should be defined as an evidentiary standard in tort law to ensure admissibility of evidence has more probative value than prejudicial impact, and to exclude evidence of prior acts that are not substantially, actually, competently, and essentially similar, in order to create consistency across courts. Thus, the standard is now defined in order to create consistency from court to court. The research question: how to properly define substantial similarity? The answers sought in this research stems from the question, how do we properly define substantial similarity? Since its humble beginnings in the 19th century, substantial similarity is now used across many different practices of law. For the purpose of this research, the focus will be on how to properly define substantial similarity in evidentiary law. The thesis statement for this paper is while substantially similar evidence is usually admissible in court, analyses of substantial similarity are found to be inconsistent across courts. Therefore, the term needs to be specifically defined to create a consistent standard. Substantial similarity is a standard that is inherently subjective and often context dependent. Therefore, there has been inaccuracy and inconsistency of application across courts. This research does a deep dive into scholarly articles and research and case law to determine what the standard requires in order to become consistently applied across courts. Contents of this presentation are article and quote, the main argument, gaps in literature and case law, the findings and perspective, and the conclusion. Quote from research. This article is essential to the research because it explains the design of the substantial similarity standard, and it also shows evidence of proper application of the standard. The standard applies when someone wants to use evidence of a prior act or statement to support an argument in a current case. The substantially similar standard in evidentiary law requires that the prior act or statement offered as evidence must be sufficiently similar to the act or statement at issue in the current case to support the inference that the same person committed both acts or made both statements. The standard is designed to ensure that the prior act or statement is probative of the issue in the current case, rather than being used simply to show that the person has a propensity to engage in certain conduct. Evidence Law and Practice by Stephen I. Friedman and Catherine T. Struve. The quote from research. This article is essential to the research because it also reviews what the standard requires, what the standard ensures and its purpose, and also what the standard is designed to do. The standard requires that the prior act or statement must be sufficiently similar to the act or statement at issue in the current case to support the inference that the same person committed both acts or made both statements. The standard ensures, and its purpose of the substantially similar standard is to ensure that the prior act or statement is actually relevant to the issue in the current case and is not being used simply to show that the person has a propensity to engage in certain conduct. And then this standard is designed to prevent the use of evidence that is more prejudicial than probative, and to ensure that the evidence presented is actually helpful in determining the facts of the current case. The main argument of this research paper is a combination of these points. First, the inconsistency in the standard. Inconsistency is found across different cases due to courts' misunderstanding or misapplication of the standard. Analyzing case law and scholarly articles to find answers on how to accurately apply the standard. Analyzing case law and articles is part of the main argument to determine why substantial similarity standard is becoming increasingly inconsistent across courts, and kind of try to dig and find the root cause. scholarly opinions for or against the standard, and the continued use of the substantially similar standard in evidentiary law. And then answers from scholars and case law on how to define the standard. These points are what will make up the main argument of this paper. Gaps in the literature. This article discusses some of the gaps within the application of substantial similarity across courts. This article is essential to our research. It is essential because it reviews the evolution of the substantial similarity doctrine. It also goes over the probative value and the substantial similarity doctrine, and then also issues found within applying the standard consistently. The article that is important to this research is called Survival of the Fittest, the Origins and Evolution of the Substantial Similarity Doctrine. The evolution of the substantial similarity doctrine. In 1872, the New Hampshire Supreme Court adopted the idea of substantial similarity as a tort doctrine. The substantial similarity doctrine had its origins in the 19th century, arising as a way of aiding courts in determining whether accident recreation evidence, either through actual recreation or analysis of other similar accidents, is relevant and admissible. The probative value and substantial similarity doctrine. The admission of prior acts requires that the evidence be relevant to a material issue, similar in kind and close in time to the crime charged, and substantially more probative than prejudicial. Evidence must have more probative value than prejudicial impact when determining substantial similarity. This is to avoid further making the standard more subjective than it already can be in several cases. And then the issues found in applying the standard consistently. Technological advancements of the 20th century led to more complex technical evidence in tort cases, resulting in difficulty applying the substantial similarity standard accurately. Over time, the substantial similarity doctrine has become a shortcut. If evidence is substantially similar in a material aspect, then the evidence was admissible, and the jury was allowed to give it whatever weight it deems appropriate. Overall, the article provides a comprehensive overview of the substantial similarity doctrine and its evolution over time, as well as some of the challenges associated with the doctrine. The gaps within case law. Two cases that will be analyzed in the paper is the case Cooper Tire and Rubber Company versus Crosby, and then United States versus Johnson. Cooper Tire and Rubber Company versus Crosby reviews shows the substantial similarity standard applied correctly in one court, but then incorrectly at another. United States versus Johnson shows the substantial similarity standard being applied incorrectly both at the lower court and the appellate court.